Here we go. Okay. All right. Okay. So we're all here, and now we're starting to record. So how I thought I'd do this morning was I'll just go through a bit of the basics. We'll confirm the exam. We'll confirm the time and everything. Then we'll go through the format of the paper. I'll give you some tips on time management, things like that. And then we can go through a couple of past exam paper questions, and I can show you what I'll be looking for in your answers and how I'm going to be marking. And then I think that'll kind of be it. And then at the end, I can answer any questions substantively or otherwise that you might have. So there will be an opportunity for you to ask questions at the end, but hopefully my sort of initial monologue will address most of your questions. But if you have, as always, if you have questions while I'm chatting, then please just raise your hand and I'll answer them. Okay, so we have the exam on Wednesday, the 15th of June, which is this Wednesday coming. It is 6 hours, and it'll be written in a lecture hall in Auckland Park campus. So you guys all have that lecture hall. I know it came out somewhere. I don't have it in front of me, but we will all have to be there. It kicks off, I think, at 0900. And so that means it'll finish at 3 o'clock in the afternoon. So bring snacks. I'll be there for the whole morning and for the duration of the exam. So I will make sure that the exam paper has been printed correctly by the university before it's handed out. There's no errors on it. And then I'll be invigilating with another individual for the course of the exam. And at the end of the exam, I will gather up your answers and obviously take them with me and mark them. So I will be there on the day to answer questions or anything like that. I'll be there the whole day. You guys have written exams there before. It's cold, so be sure to dress up warm. And like I say, if you want to bring snacks or anything in, I don't know what the university rules are on that, but my rules are that's fine, as long as you don't sort of annoy other people, like chewing peppermints or something like that, which is annoying. Then I'm going to be fine with you just, like sustaining yourself. So yeah, so it's a marathon. It's a big one. It's also open book, so you can have whatever documents you want with you. I'm not going to worry about that because there's no rote questions in the exam. It's all manipulation, compare and contrast. What do you think about this? What do you think about that? How could this be improved? Those kind of questions. So, you really have to sort of think about it really, and it's not so much just committing a lot of data to memory, and anybody can do that. That's real undergrad stuff. We're long past that now. So yeah, so here we are. Okay, so the exam is 100 marks, which doesn't seem a lot, over 6 hours. That's quite a lot. So I apologize in advance if I'm going to be a little bit basic about this, or reductive, oversimplified in my analysis. But I mean, there is exam technique, and it's very important. So you look at how many questions there are, and you look at how many marks there are. Okay, so for example, if there's 4 questions and there's 25 marks each, then that each question is 25% of the paper, and you should spend 25% of the time. So I think if it's about an hour and a half per question, right? If it's a 25-mark question. So, that's a lot of time to sort of think about it and plot your answer out and give it like, can we bring digital devices? I'm not too sure. You'll have to check the university rules on that. I don't think you can bring digital devices. Yeah. Udo, apparently you've appeared twice. So, okay, yeah.
Yeah, I think that's my laptop connecting.
Okay, cool. The answer is I don't know about digital devices, but I think probably not. But as I say, I'll confirm that with you. But that's not to say you can't bring in, you know, like wads of paper, a suitcase if you want. And yeah, so okay, so we've got a question for 25 marks that you can spend up to an hour and a half on. So what I would suggest you do is actually you don't budget the full hour and a half. You sort of look to spend about an hour and a quarter on that, because you know your 6 hours will kick off, and then what I think you should do is you should read the whole paper, and then you just sort of ruminate on which question you want to start with, and which one is the low-hanging fruit, because the questions are like that. There is low-hanging fruit in the paper, and there are, on the other side of the coin, there are questions that are difficult. So, you know, there's a spectrum of questions like all exams. So what you should really do is you should start with the easy one, and just go for it. And because what tends to happen is, you know, as you work through the easy ones, the stuff that you know, the stuff that comes quickly and naturally to you, your mind is working on the other ones in the background and churning away, and it might throw up a few answers or points that you think would be correct to include in your answer. And you know, as a guy who's written a lot of exams in my life, I can really tell you that, you know, trust your instincts. So when you know, when there's a question and you're not sure about the answer, but there's a little voice in your head that says this, or look at this, trust that voice. Okay. You'd be amazed. I mean, we've sat through so many hours of lectures together. I think we've had, you know, like 20 or 21 hours of lectures, and you did the essay, and you know, you guys have really been exposed to this stuff. It's in there, it's between your ears already. And so, you know, when your subconscious throws up an answer, believe in yourself and trust in yourself, and go with that answer, and only second guess yourself, only go against that initial answer that your mind throws up if you are 150% sure that it's wrong. You know, I really can't emphasize enough how much you have to trust yourself for this exam. And I want you to sort of look back at your career, and in particular your academic career, and see how far you've come, and the mountains that you have climbed to get to this point. You know, think of all those dreadful exams that you wrote, and you were convinced you weren't going to do well, and yet here we are. And you may have failed a few along the way, I don't know. I certainly failed several along the way, and you learn a lot from failure. But the fact of the matter is that you are here, and you can do this. You can absolutely do this. I'm not going to ask anything of you that you don't know, or you are not capable of constructing an answer to. You are postgraduate LLB students at the University of Johannesburg. That is a rarefied and coveted position. You guys are the cream of academia, and you guys can do this. So you've also had an amazing lecturer. So you've got everything you need for this exam, right? And a big part of the battle is your own demons that you have to fight. And you can really do this. So you know, just break it down. Be cool on the day. Be cool. Believe in yourself. Trust in yourself. Trust in me. And yeah, we'll get there. Okay, so you've got this question. It's 25 marks, and it's clearly some kind of essay. Okay, fine. Let's break it down. I'm a very simple marker. Okay, if it is 25 marks, there are 25 points, things that I want you to say. In a 25-mark question, there are not only 25, there are about 30 or 35 things that I will accept. So, you know, it's not like there's only 25 things to say and you have to say all of them. There are lots of things to say, and there are 25 marks up for grabs. But my point is simply this, that it is a mark a fact. Okay, that's how I mark. It's not like I read your essay and I go, that's a 67 or whatever. I'm like, read through. Oh, yes, that's correct. That's the right case. Tick, 1 mark. Yes, that's the correct point. Tick. Yes, we discussed that in lectures. Tick. Okay, so it's it's easy to sort of, from your point of view, to give me what I want, and I want facts. I want factually correct things. I want, points that have been made, arguments that are correct. I want case law. I want you to cite legislation, etc., etc. The applicable clause, the applicable cases, argument, which has been sort of falls out of that interpretation, and it's 25 marks, 25 points, 25 ticks. That's kind of what we're looking for. Yeah, so it's easy to kind of do well from that point of view. In these exams, there is stuff in there that obviously I'm very familiar with it, right? So because it's a handwritten script that you'll be given to me at the end, I'm familiar with everything, right? I know all of these sources. So I won't be running it through Turnitin, but I'll be doing my own Turnitin up here. And I know the phraseology which is in the cases. I know the phraseology which is in the articles and things like that. So, don't slavishly copy out of these things just because you're not running it through Turnitin. And I don't want to say, I'm not saying I don't trust you. I'm just saying that just write this like you would write it and it was going through Turnitin, because even though it's not going through Turnitin, I know the wording of these articles. And if I see that you've copied whole chunks out of these things verbatim, then obviously that's not going to sit well with me. So, or if you do copy, like you do, give reference it to say, Holmes J said in this case, and then you can copy out a bit. That's fine. That'll get you a mark because you if it's relevant, because you're quoting the right thing. But don't claim Holmes J's words as your own. That's an important. One shouldn't really do that. So, okay, so that's exam technique. Believe in yourself, time management, a mark, a point, a mark, a fact, and I think take it from there. So an hour and a quarter, it's quite a long time. It's it's more than enough to jot down 25 things. And again, we come back to your classic how things are done, right? So like if we look at some previous papers, let me just bring them up here. Of course I can't find them. Here we go. Okay, so this is from last year, 15th June 2021. Okay. Well, I mean, there's lots of them. Discuss the opportunity, question 2. Discuss the opportunities provided by the Patents Act for a third party to adversarially engage with the patentee. Exemplify your answer with case law. So, okay, so now you're thinking that's 20 marks. Okay, fine. So adversarially engage, what does that mean? That means like oppose or, basically fight. Okay, and so where do you fight? You fight in the Court of the Commission of Patents. And what matters go to the Court of Commission of Patents? Well, the first one, the most obvious one, is infringement, right? So when somebody is allegedly infringing a patent, the patentee adversoriously engages with the third party, right? So it's infringement. So, and then you think, well, what falls naturally out of infringement is revocation, okay? Because revocation is usually pleaded in defense, or it can just be itself, So it's revocation, it's infringement. What else? Okay, so then now you have to start scratching around and thinking, and then the first thing that comes to mind is opposition. Now, there is no opposition to grant of patents in South Africa, but there is an opportunity to oppose post-grant amendments, right? So that's another opportunity to go to the Court of the Commission of Patents, is when a patentee tries to amend his patent and it's after grant, and you don't think that his proposed amendments comply with the requirements of the Act, you can oppose that. There's a notice of opposition that you can do. There's an advertising. So there's that, okay? And then you dig deeper down and then you realize, oh, okay, it's possible to oppose the restoration of a patent. So where patentee has forgotten to pay or didn't pay their renewal fees and it goes past the 6-month deadline, it goes past the deadline for payment, then there's a 6-month grace period, and then it finally lapses. But they can revoke it if there was no undue delay as soon as they came aware that they hadn't paid the renewal fees, and it was always unintentional that for them not to pay the renewal fees. They always had the intention to pay, but for whatever reason they didn't. And then they can make application for restoration, and that can be opposed as well. So you see, now you've already got four instances where you're before the Court of the Commission of Patents. Divide 20 by 4, it's 5 marks each. Now so there's case law, there's the Act. So you give me a case, you give me the bit from the Act, and you give me the what you're going to do. That's 3 marks straight there. Dum dum dum, easy. So when you get this question, you see how I'm breaking it down to like what I want, and that kind of thing. So it's quite sort of it's relatively easy when you break it down into bite-sized chunks like that. Okay, so let's stick with the same question paper. And question 3. Patent applications in South Africa are not substantively examined. Okay, we know that. We've discussed that. Discuss the advantages and disadvantages of not having substantive search and examination. Briefly discuss how the IP policy first phase attempts to address these disadvantages. 20 marks. Okay. All right. So what do we want? We want advantages and disadvantages of not having substantive examination. So, the advantage. So to be fair, we didn't really discuss this per se this year, but like last year, we did spend a bit of time discussing advantages and disadvantages. So what I'm saying to you is, all of the questions in this year's paper we have discussed during the course of the year. And obviously I don't emphasize the same things every year in my teaching of the course. Like in 2020, for example, there was a massive emphasis in the teaching of this course on vaccine access and compulsory licenses and trips and things like that. And we've just like skipped over that this year because it's not so relevant. And so you can see in 2021, we also had a question about opportunities for government to gain access to privately owned applications and granted patents. We have discussed that this year, but it hasn't been emphasized in our discussions. So, I try to sort of give it different areas of focus during my presenting of the course. And so I want you guys you won't be surprised on Wednesday when you get the paper and you'll see, oh, I remember John actually discussed this in one of the lectures. So you have been sort of preceded in the sense that I've planted a seed in my lectures as to what is coming in the exam. There have been different emphases along the way, and you'll recognize that on Wednesday morning. You'll think, ha, sneaky. Okay, I see where he's coming from, and so that's important. So when you look back at these old papers and you think, wow, adversarial engagement, that John hasn't spoken about that this year. The fact of the matter is, even you could probably answer that question with what you've got now, but you haven't been sensitized to it. So, it's this kind of analysis which looks pretty hairy when you look at it, but then when you contextualize it as in terms of what's been emphasized over the lectures, that's sort of really important. But the fact of the matter is, it's you take these questions and then you sort of look at them and you think, okay, what does he want? And you just jot down like a couple of points, and then you realize that how I'm breaking it up and how the mark schedule is actually going to work in practice, you know. Like I want different things from you. So you need to be quite sort of rigid in your approach to say, okay, I need to tell him this and I'll get a mark. I need to tell him that and I'll get a mark. It's not airy-fairy. It's not airy-fairy at all. It is very mark orientated. And again, you know, when we came to when you did your assignments and we discussed your assignments afterwards, you'll recall how much I emphasized the format that I like essays: intro, discussion, conclusion. You know, this is what I'm going to tell you. Now I'm going to tell you, and this is what I told you. A 20 or 25 mark question is usually a kind of, you know, kind of an essay type thing. So I want to be able to be taken by the hand and led through your arguments, right? And led through your answer. I don't want a stream of consciousness. I want it to be constructed. I want it to be logical, and I want it to be fact-filled. And so, you know, from that point of view, your assignment is going to be very instructive as to how I wanted it done. So, yeah, so I think that's the most important thing. If we look at some other, if we look at the 2020 paper, okay, question 1. In your opinion, is the South African patent legislation and body of case law pro-patentee or pro-third party? That, on the face of it, is like a difficult question. Hi, Sally. Yeah, what's up?
Morning, Prof.
Hi, morning.
Okay. Even though we didn't do much about SSEs with regards to that question too,
yeah.
I just wanted you to clarify for me, especially with regards to the disadvantages, right?
Yeah.
Okay. Where in your memorandum you are giving points of evergreening of former patents.
Okay, so what are we? Question 3, hey?
Yes. So I'm not really catching up on or understanding this evergreening of former patents.
Okay, so so cons of no substantive search examination. Evergreening of pharma patents. Okay, so what happens in evergreening of a pharma patent is so how pharma patents work is that they discover the molecule, right? They discover the chemical compound, and they realize that it has therapeutic effects against, you know, say for example, hair loss. If you take this drug, then you stop going bald and your hair actually begins to grow back. And so how the patents work is that the first patent will just claim the chemical. So, you know, it's got this molecule and that molecule, this is what it looks like, etc., etc. And it's used to treat a male pattern baldness. Okay, so that's fine. So then what tends to happen is the drug manufacturers then look at this compound and they say, well, one of two things can happen. They suddenly figure out a better, cheaper, faster way to make it, to synthesize the compound. And so they'll patent a method of production of this compound. Or they will figure out that if it's administered together with another compound, it has a beneficial effect. So you start having the second generation of patents coming out on, you know, co-administration, or different ways that you make it, or different ways that you administer it. You know, so the first one said it was a tablet, that's fine. But now this one says it's actually a plaster that you just put on and it gets absorbed through the skin, you know. So you have these different ways of administering the chemical compound. Chemical compounds are called APIs, active pharmaceutical ingredients. And so if you have your first patent, which is directed to the API and its use thereof in the treatment of male pattern baldness, that's fine. And then you have multiple patents will come after that for co-administration of the API with sugar, administration of the API transdermally, you know, and then you get things where, oh, we figured out that it also treats leprosy. So then you'll have a new patent directed to this compound for use in a method of treatment of leprosy. So you have all these multiple patents coming out. So, but what's important, what's really important, is that each of these, the next generation of patents has to be novel and inventive over the first API patent, the first patent that covered the compound, the first patent that covered the active pharmaceutical ingredient, the API. So if you don't examine these other patents, right, and they are in fact not novel or not inventive over what was taught in the first patent, you're going to give the pharmaceutical manufacturer extra time of exclusivity, and that's called evergreening, which just means that, you know, the field is always green for him, because he's just, even though he got his 20 years, now he gets a, you know, he gets a, and then 5 years later he filed another patent which should never really have been granted because it's not inventive over what was taught in the first one. If you don't examine that patent application, it's going to last for another 20 years. So it's going to give him another 5 years after the expiry of the APA patent, and he can just keep doing that, right? Just patenting these improvements. And if these improvements don't comply with the Act and are not novel and are not inventive, then he just gets to extend his monopoly on the never ending, and that's called evergreening. So if you don't examine patents and make sure that they comply with the Act, there's a big danger that pharmaceutical manufacturers can, in fact, indefinitely extend their monopolies by filing these nonsense patents which don't comply with the Act, and that is called evergreening.
Okay, thank you.
Hope that makes sense. Yeah. I'm just looking at this. I didn't realize I gave you the memorandum. I'm quite impressed. You see how easy it is. 20 marks and how many points there. Okay, so it's interesting. You see, in addition to the points set out below, up to 3 marks were available for structured and coherent argument. This is exactly what I was talking about earlier. Introduction, discussion, conclusion, you know, that kind of thing. There are marks available for making it easier for me to mark. So let's have a look at this. 20 marks, pros, 4 pros, 2, 4, 6, 10 cons, okay? And then a discussion of the IP policy, 2, 4, 6, 7. Okay, so that's 17 marks for things and 3 marks for structured and coherent argument. So there's 20 marks set out in the memorandum, but that doesn't mean to say that there aren't more marks available out there if you make a decent point, which I hadn't thought of in my memorandum. Just because I didn't think of it doesn't mean it doesn't get points, right? I'm not that egotistical to think that I know everything. I'm very interested in what you have to tell me. And if you tell me something and I think about it and I go, Tabisa's right, you know, I didn't think about that, but yeah, that's a point or two right there. So you know, there is 20 marks doesn't mean there's a 20 mark question doesn't mean there's only 20 marks available. There's more available for stuff, but you can see how I break it down like that. So hopefully that's sort of quite useful. Okay, let's go back. Opposition to question 1. Opposition to restoration, compulsory license. Cool. I hadn't thought of that earlier. Opposition to post-grant amendment. Yeah, that's fine. Revocation, and then infringement. So wow, 20 marks. Just look how much there was available for, you know, on that question. What was question 1 in 2021? Yeah, the government acquisition of marks, section 4, section 78, section 56, yeah, section 79, and then there's a conclusion and argument. So yeah, so I think you know, when you look at my past exams, the 20 and 21s, and my memorandums, you can see how it is actually quite quantitative in my analysis, in the sense that it's a factor point, and then there's some marks available for structure. It's not qualitative. I don't just sit back and just give you an impression of your answer, what I think your answer is worth. It's my papers are super easy to moderate, because the moderator, we either agree that's worth a point or not. So my my moderators come back and there's almost always no change. The only changes moderators have made to my papers in the past is when I've added up incorrectly, and you know, and that happens. So yeah, so there we have it, guys. I think so. It all comes down to structure, and it all comes down to sort of argument, contextualization, and most importantly, it comes down to the things that we have discussed over the year, right? So what have we discussed over the year? We've discussed artificial intelligence. We've discussed, let me just check here. We've discussed, you know, the IP policy. There's always a question about the IP policy because the IP policy is where we're going. The IP policy dictates the IP landscape that you will practice in. So it's really important that you understand the IP policy and be able to talk about it. So, you know, we've discussed the importance of that and, you know, what the IP policy thinks is wrong or where the current legislation falls short and how it plans to address it. That's a very common theme in these things. We spoke about, there was a lot tying in about the, you know, the Biodiversity Act and the changes that were made to the Patents Act, and how, you know, there's a similarity of purpose between the two acts, which is to encourage innovation, encourage use of natural resource, make sure that the fruits go to the right person. You know, in the Patents Act, it goes to the inventor or the person acquiring the right to apply. You know, in the Biodiversity Act, it goes to the community. You know, the sanctions for getting it wrong, et cetera, et cetera. So those are very important aspects about how, you know, the central philosophy of the Patents Act is actually reflected across in the Biodiversity Act. So that's quite important. And again, it goes to this, you know, I've always banged on about how important the philosophy of the Patents Act is, about how it's there to solve problems. It's there to make sure to incentivize people and communities to put forward solutions which make our lives better. That's the whole point about the Patents Act, and how if you do, and the barrier to entry to get that monopoly is high, and how, you know, the things you have to satisfy to get there, and the things you have to do to get it, and how it can be taken away if you don't do things correctly. You can't appropriate other people's ideas. You can't hold invalid claims over the population. You've got to, you know, act with bona fides, et cetera, et cetera. The conduct of the patentee is important to make sure that you can do your rights. So, and you know, the extent to which that is reflected in other acts is important. And then finally, I can tell you absolutely, even though it was only one lecture, it was a heavy lecture. There was not only the stuff we went through, but you will also see that I put up quite a heavy presentation, which is part of the syllabus. There is definitely, most definitely, a question about designs, okay? So don't skip designs. Don't think that, oh, he won't ask designs this year. I will. Designs are important. It's part of the course. And so when we talk about designs, we tend to, I think last year I was comparing designs and patents, you know, how they work, the similarities, their differences. So that's a very typical thing. And you remember that this year we spoke about, you know, an aesthetic design versus a functional design, how they fit together, how they work together, the differences, the similarities, et cetera, et cetera. So these are all things that were emphasized during the lectures, and so these are things that you should obviously focus on in your studies, bearing in mind that, you know, you might be asked to comment on these things in a structured and measured way. So yeah, the other thing, let me just check. Yeah, I think that's. Yeah, I think that's more or less everything that I can say today. I mean, we can go over parts substantively, but I think everything you need is there. The lectures are recorded. Dean and Dyer gives you everything you need to know. The cases give you everything you need to know, and to the extent there's some explanatory notes which popped up on Blackboard, some examples. I think that you should probably, I think you have at your fingertips everything you need. If there's any concepts which aren't clear, I'm very happy to explain them now. But as I say, I think you've just got everything, and what you really need to do is go over your lecture notes and just think about things that we've discussed and points that I've dwelled on in the course of my lectures, and then you'll see you'll be able to sort of focus on those areas in your preparations. My final comment is just to say that I did put up 25 questions to ask, or a checklist of questions for completing a license agreement. Licenses are very important. I would definitely have a copy of that list with me on the day. Licenses are, getting a patent, getting a design is one thing, but monetizing it and making it work for you is another. And licensing is your principal weapon in that endeavor. So you need to have a good understanding of licensing, how and why it works. And that checklist of questions, I think, is quite important. So don't forget that at home on Wednesday. But yeah, otherwise, that's it from my side. So here I am to answer any questions that you guys might have or concerns. The one thing I don't actually know about is, when was the last time you guys were on campus? I'm assuming we can all get onto campus. Do we, everybody comes and goes? I know my daughter down in UCT, there's no issue. WITS is fully functioning. I think as far as you guys know, campus is up and running and it's not a problem to get on or off. Yeah, I don't know if you guys have heard anything, but that's my understanding. Okay, cool. All right, guys. So a quick lecture. I mean, only 45 minutes so far, but plenty of time to answer any questions you may have. Sally, yeah.
Yes, Prof. Question number 1, is it number 1? The one for pro-patentee and third party. I think it covers a lot of concepts, and those concepts, that's the real patent syllabus. And
sorry, say again, Sally? Yeah. Question 1, which paper?
2020.
Okay.
Yes, the one that is talking about property and third parties. And if only we could understand these different concepts that are coming up from the memorandum, I think we would be home and dry.
So question 1, in your opinion, is the South African patent legislation and body of case law pro-patentee or pro-third party? That question.
Yeah, if you could maybe just run through it, because the second point, narrow anticipation, I don't have much. I'm not really sure if I could
discuss and motivate your position with case law and provisions of the Act. That one. Okay, so let's talk about question 1. Okay, in your opinion, is the South African patent legislation and body of case law pro-patentee or pro-third party? Discuss and motivate your position with case law and provisions of the Patents Act. So what we were looking for there is to say, well, listen, all the different sections of the Act, do you think they favor the applicant for a patent, or do you think they favor, they disadvantage the applicant and make it more difficult for him? So let me just see. So if you look at the memorandum, so we say, okay, so the first thing is there's no right or wrong answer for this particular question. You just kind of go through, and it's my personal view that on balance, the Patents Act favors an applicant, a patentee, but you know, if you came to a different conclusion, you weren't going to be marked down. And so what I did was I just sort of listed like a whole lot of things that the Patent Act provides for. And I kind of like said, well, does that advantage or disadvantage the patentee? So, and really it was in no particular order. It was just all the different things that I could think about. So the first thing is no substantive search and examination. So I think that's very much in favor of an applicant, right? Because it suggests that it's easy to get a patent. He would get that patent, you know, irrespective of the substantive aspects of his application, because nobody's looking at it. So you could basically get a patent for a wheel in South Africa, even though it's extremely well known for tens of thousands of years, because nobody's looking to see whether the subject of your application is novel or inventive. So that's pro-patentee. You know, narrow anticipation, easy correction and amendments. I mean, for the most part, certainly pre-grant, there's no opportunity for people to object.
Okay, may you kindly maybe elaborate on the narrow anticipation?
Elaborate on?
On narrow anticipation.
Okay, so you should read Netlon versus PACnet, and that talks about, so you know what anticipation is, right? So that is where somebody says, you know, you're claiming a green bicycle and your invention is anticipated by this canary yellow bicycle here, which appeared in the public domain before the date of your patent application. So this canary yellow bicycle anticipates your invention. That's what anticipate means. So the courts in Netlon versus PACnet said, well, I'm going to take a very narrow view of what I consider to be anticipation. So the applicant claims a green bicycle, and the bicycle which is said to anticipate a green bicycle is in fact canary yellow. So what I'm going to do is I'm going to look at what I mean by green. And I believe that when I look at the Pantone references of all the different colors of green, etc., that green is this range and canary yellow is that range. So the two ranges don't overlap in color. Green is distinct from canary yellow. So I'm going to narrowly interpret what that previous anticipation actually covers. It's only those canary yellow ones. The invention claims a green one, so the invention is novel over the alleged anticipation, because I'm going to narrowly interpret what exactly canary yellow is. So I'm going to favor the patentee by giving him a broad interpretation of what he's invented and a narrow interpretation of what is out there at the moment. So that's how we get to narrow anticipation.
Okay, thank you. And then let me just put them on the point number 22. It's a pro third party, where you saying you're putting IPR Act.
Point number 32.
22.
22.
Yes, on the same memorandum.
Yeah. Okay. So remember we discussed the IPR Act, right?
Yes.
And so you know the IPR Act is directed to inventions which have been, or intellectual property which has been created through the use of government funding. And so it would relate mainly to research conducted by either science councils like the CSIR or MinTech, or most commonly universities, which receive huge amounts of government funding to fund their operations. So what it's basically saying is that even though, so, you know, you come along and you engage a university to solve a problem, and in so doing they do it, and that's patentable. All of a sudden, you as the guy who gave them the problem, and you know, but for you they wouldn't have come up with that solution, because they hadn't even realized there was a problem. But you know, you came along and you solved that problem, or you asked them to solve the problem, and they did. But that, you don't get a monopoly on that because of that. So that solution then sort of is owned by the government, and you know, they get to tell you how it's going to be licensed out, and the university gets to license it out. So that is very disadvantageous to the actual owner of the or the creator of the intellectual property, because it gets disseminated to third parties, and no real monopoly accrues to the person who was seized with the problem in the first place. So the problem is solved, but the solution doesn't belong exclusively to the person who remembered or recognized that there was a problem. So automatically that must benefit third parties, because no monopoly is created on the solution.
Okay, thank you, Prof.
Cool. Okay. Yeah. Okay. That seems to be everything. Yeah, on that one.
Prof.
Any other questions? To be so, yeah.
On this very same question, point number 15, wouldn't you argue that Section 48 of the Patents Act is actually pro third party? Because
okay, let's look at Section 48. Let me just get it up here. Section 48. Rights of a patentee of a restored patent. Okay, so what did we talk about here? Restoration provisions, Section 47 and Section 48, pro-patentee, Section 48. A patentee of a patent restored in terms of Section 47 shall not, by virtue of the provisions of this Act, institute any proceedings against or recover any damages from person who infringed the patent after the lapse of the period of 6 months from the date on which the renewal fee was due and before the date on which the application for restoration of the patent was advertised, or who used, offered to dispose of, or dispose of any article, or during the period set out in paragraph A, commenced using or exercising the invention, uses or offers to dispose of. Okay, so basically, and then Section 2 says, where a patent has been restored under Section 47, any person who during the period referred to in Section 1A has expended any time, money, or labor may apply in the prescribed manner to the Commissioner for compensation in respect to the time, money, and labor. And the Commissioner may assess the amount of such compensation or to be granted and determine the time within which such compensation shall be paid. Any amount assessed under Section 3 shall not be recoverable as a debt or damages, but if it is not paid within the time determined by the Commissioner, the patent shall lapse. Okay, so that's an excellent question to be. So is that pro-patentee or is that pro-third party? I think it's pro-patentee, but I can understand where you're coming from. So let me just put it like this. So the patent expires and you think, well, hey, cool, I'm piling in here. So you build a factory and you expend millions of rand building that factory. Then the patentee wakes up to the fact that he should never have allowed that patent to lapse, and he manages to convince the commissioner or the registrar that such lapsing was unintentional, and he came after you as soon as possible. Now you've built this factory and you've been making and selling the patented widgets for, I don't know, 2-3 months, and then all of a sudden the patent is restored and you've got to stop doing what you were doing. So now you've expended time, money, teams of people, you've paid them, you've built this factory as a third party, and now all of a sudden the carpet is pulled out from underneath you. Sure, the patentee has to sort of pay you after you've got to apply to the Commissioner for damages and prove all of this, and and the patentee might have to pay you for out-of-pocket expenses, etc., etc. But the fact of the matter is, he gets to stop what you're doing, even though he was an idiot and forgot to renew his patent. He still gets to stop you. It's not like once you start, you can continue what you're doing. You have to stop. And that can be seriously disadvantaged, because you invested all of this money to build a revenue stream from making these patented widgets, and then that revenue stream is suddenly shut down, and yeah, you get your out-of-pocket expenses, but that's not really, you're still way worse off than had you been allowed to continue to do what you were doing. So I do think it's pro-patentee, even though there are some downsides to the patentee. He has to pay you for building the factory and maybe the salaries that you paid your guys, but the patentee is still laughing because he's got his monopoly back, and you back to square one. So I do think that on balance, I can see that it's not all bad for the third party who built that factory. But I think on balance, it still favors the patentee because he's the guy there sitting with his monopoly, even though he was stupid to have let it lapse. So that's how I approach it. But if you can argue differently, Tabiso, on the day, trust me, my doors of perception will be open to any argument that you might have. But I don't consider myself to be right all of the time. I'm always listening to whatever you've got to say.
Okay, thanks, Prof. Because my way of thinking was the patentee can't actually claim for damages or institute infringement proceedings or when the patent
while the patent is lapsed.
Lapsed, yes. So that, in my point of view,
which bit are you reading from, Teresa?
Third party. Prof?
Yeah.
So the patentee can actually claim for damages whilst the patent or during the period or for the period the patent was lapsed.
Yeah, that's right. Yeah.
So I was thinking maybe the third party can use that as a defense if the patentee instituted in infringement proceedings for damages.
So he would only be able to do that so he only escapes damages and infringement for the period after the lapse of 6 months from the date on which the renewal fee was due and before the date on which the application for the restoration of the patent was advertised. Okay, so after that, if he continues with what he's been doing and the patent gets restored, then he is liable for damages and infringement. It's only that brief period where the patent wasn't in force that he escapes damages and he escapes an infringement action.
Yes. Okay, I get it. Makes sense, Prof.
Cool. And again, so you look at that construct and you realize that I think it favors the patentee, but again, it's sort of contextual and we've got to look at it from first principles, which is, why do they have this? And it's like, the patentee is sort of rewarded for providing that solution and for giving us that invention, which provides a technical advantage. And that's like a golden thread that runs through the act, that the patentee must always be encouraged. We must encourage people to file patents. So we must make it easier for them. And so that's why I think there's probably a pro-patentee bias, as long as the patentee plays by the rules. Yeah. Okay.
Thanks, Prof.
Cool. Rudo, anything from yourself, or are you good? Yep.
Nothing my side.
Nothing from your side.
Yeah.
Okay. All right, guys. I hope this morning was useful. What we'll do is I wish you all the very best in your preparations. And as I say, Tabiso was telling me earlier just how much there is to go through, and I do appreciate that. I really, really do. But you guys are right at the end, and just think about how happy you're going to be at 3:05 on Wednesday afternoon when this is behind you, and I gather up your scripts. Just one last thing on the day. It'd be really cool if actually these are sort of 20-25 more questions. Yeah, no, it's okay. I was going to say one question per answer booklet, but don't worry about that. The answer booklets are big, so you use as many as you feel are necessary. That's fine. And yeah, I would say that. Okay, so I think you all heard me say I will be there on the day. I personally collect the exam scripts. I check the exam scripts before you get them, and I co-invigilate the exam on the day with another guy. So I'm there if you have questions, if you have problems or anything, and then I take the exam scripts with me at the end of the day. So I'll be there with you on the day. And yeah, so I think if you have any questions or something occurs to you in the middle of the night, just drop me a mail. Like I said, I do. I'm very responsive to mail, and yeah, and I'll answer any questions you might have between now and Wednesday, or even on Wednesday morning before the exam. So, and again, don't stress out too much. You guys can do this. You've got what it takes, and yeah, I look forward to seeing you on Wednesday.
Will it be a typed exam or we are using answer book?
Will it be a what exam?
A typed exam. Are we typing on the laptops or what?
No, I think you're writing in exam books. That's my understanding. I don't think any digital devices are allowed, but that's my understanding. It's an old school exam.
Sorry, can you come back? I'm not getting you because last time we did the exam, we did it on MS Word and we just forwarded everything to.
Now, was this when you wrote on campus?
No, we were writing in different places.
No, so we're writing on campus on Wednesday. Yes, this is not an online exam. This is a physical exam, and on campus in a room, and you'll be writing into exam books, and I'll take those exam books with me at the end of the day.
So we can't bring our laptops.
No, I'll confirm that, but my understanding is no digital devices. No, but it's open book, so all the books and everything you can bring with you, but no phones, no laptops or anything like that. No.
Okay, I see.
Prof, please confirm the fact that we can't bring digital devices, because I think some of us still have material on our laptops that we'd like to consult. And if we can't, maybe you can know beforehand so we can print those things out.
Print those materials is
yeah.
Okay, I'll confirm with you, but yeah, last year last year we all wrote externally. So okay, I'll confirm with you about that. Yeah, that'll come through in the next day or two.
It's the fourth industrial revolution, Prof.
Yes, I do know that. But we are beholden to the rules of the university, so I must just familiarize myself with them. But my understanding is that, yeah. But I'll confirm. I'll confirm.
Okay. Thanks, Prof.
And Prof, sorry, which campus are you writing on? Is it the Kingsway one or the Bunting one?
Auckland Park, which I think is Kingsway, huh? APK.
Oh, Kingsway. Okay, thank you.
Yeah. So let me just check here. I think I just want to make sure that we're all on the same page here. Here we go. June exam schedule 2022. Okay. Opening up. 15th June, patent law, Professor John McKnight. Oh, it's 08:30 to 13:30. That's not right. It's longer than that. It's 6 hours. But the venue is.
It's not 9 o'clock. It's 8:30.
Yeah, 8:30. So I mean, you guys should have this, right? And the venue is CLES 301.
No, I don't have this one.
Oh, okay.
CLES 301. Where is that?
I don't know myself. I'm sure we'll have to find it on the day.
Some of us, we had never attended classes at UJ. So I only know how to get to the library.
You only know how to get to?
To the library.
Yeah. Well, Sally, have you never been onto campus before?
I've been on campus, but not on the. I don't know. I don't have any idea where the classes are.
Well, it's so CLES is C block, and then LES I think stands for. I'm actually not too sure, but you know, it's sort of easy to find, and you can ask someone on the day, and they'll direct you there. So I think it shouldn't be a problem.
I think it's the block that's across from the library. If the library you're talking about is Kingsway, so I'm sure if you get there and you ask, someone can direct you to that the wing.
Okay, thank you.
Yeah, because I'll also be looking for it. I'm not sure exactly where it is.
Just get there early. I'll round everyone up before.
That's very good advice, Tabitha. I think we should get there early. Yeah, because you don't want any drama. You want to be in a good headspace on the day. And look, I will say that I'm going to be, because you know, coming onto campus and you know it's got its challenges. Don't be late, but I will be quite sort of cool about, you know, if we want to start a little bit later, but don't rely on that. Okay, be there for 8:30. If it says 8:30, be there for 8:30. But you know, I'm not gonna be like really difficult about it. But please, you know, get there early. Get there early. But I will be a little bit lenient, you know, because there's difficulties and we all have to find the venue, etc., etc. So, but yeah, get there early, and I'll see you on the day. Yeah.
Okay, thank you.
Okay. Nothing else? All good? If there is anything else, just email me, and I'll drop you guys all an email about digital devices in the next day or two.
Okay, thank you.
Okay. Thanks, guys. Talk soon. Bye now.
Bye.